the Canadian Dominion was established in the year 1867 with the passing of British North American Act 1867 by the Westminster. After the 1867 Act, the Dominion of Canada was established, but there were two major drawbacks. One was that there was no amending provision, that in case this BNA Act 1867 is to be amended, there is no inbuilt procedure prescribed under the Act for the amendment of any of the provisions of 1867 Act. And the second major drawback was the Charter of Rights have not been established, have not been given the constitutional status. And there was also no demand till the Second World War. After the Second World War, there was some demand. However, in 1948, with the adoption of United Nations Declaration of Human Rights by the United Nations, most of the countries, especially the developing nations who got the independence during that period, adopted that Bill of Rights in their constitution, and they made the Bill of Rights as a part of their constitutional scheme. Thereafter, a surge of demand for the Bill of Rights raised in Canada also. And finally, there was a lot of opposition regarding the promulgation and establishment of Charter of Rights in Canada, because the parliamentarians did not want that such a restriction be imposed upon their functionality of legislation. However, in 1960, under the premiership of the then Prime Minister Dai Van Belker, the Bill of Rights were given the legal status when Canadian Bill of Rights was passed by the federal parliament and has given a statutory status. Very interestingly, this federal law giving the Canadian Bill of Rights as a statutory status is applicable only on the federal laws. It is not applicable against the provincial laws. Thereafter, the Trudeau Sr. became Minister of Justice in 1965. He pushed and tried his level best to push the Charter of Rights within the scheme of a constitution. There was a strong resentment among the provinces, and finally he prevailed upon almost all the provinces except one, that is province of Quebec, which has dissented. And in 1981, this idea became a truth, became a reality under the premiership of Trudeau Sr. when Canada Act 1982 came into existence. Canada Act 1982 was passed again by the UK Parliament, and it has attached as a schedule the Constitution Act 1982. And this Constitution Act 1982 now includes the Charter of Rights. Most of the rights which have been declared as basic rights by the Canadian Bill of Rights were included in the Charter of Rights by way of a Constitution Act 1982. However, the Canadian Bill of Rights was not repealed by the Charter of Rights, meaning thereby the Canadian Bill of Rights still subsists as a federal law available qua the rights which have not become the part of the Charter of Rights. There are two rights, very important rights, which have not been included in the Charter of Rights. One is due process clause, another is a fair hearing for the determination of rights and obligations. Now, these two prominent rights are still available with the people of Canada, by the implication and application of a federal law in the shape of Canadian Bill of Rights. However, I may clarify here that this Canadian Bill of Rights is a federal law and is applicable only against the federal laws. So these two rights which have not been included in the Charter of Rights but have become are part of the Canadian Bill of Rights are available only against the federal laws and not against the provincial laws. Thank you very much.